everyone. We will start shortly. So this is the panel on legislating living customary law. We will start this afternoon with Professor Nklapo. I just wanted to make sure that he has joined us before I start. Professor Nklapo, are you in the room? Give me 30 seconds to introduce you. Okay. And then I will ask you to unmute. Yes. So I cannot tell you everything about Professor Nklapo because there's too much, but I'm sure almost everyone here is very familiar with his name for very different reasons. But one of the most important reasons he's here with us this afternoon to talk about the problem of legislating customary law is because, amongst so many other things, he was a full-time commissioner on the South African Law Reform Commission. And in that capacity, he chaired the Project Committee on Customary Law and was instrumental in the development of the Recognition of Customary Marriages Act, which was passed by Parliament in 1998. So we're very, very grateful that he's joining us this afternoon to talk about this issue, I suppose retrospectively, many years down the line. Welcome, Professor Nklapo. You have 15 minutes. The moderator, CN, will let you know when you have 5 minutes to go. And after the presentation, we will pause for translation in the venues. So over to you, Professor Nklapo, and please also switch on your camera. Perfect. We can see you.
Is that okay? Thank you so much, Vermin. I'm going to try and make this fast and see if we can catch up on some of the little time we've lost. I wanted to start off very quickly by sharing the reasons why I'm excited and very grateful to have been asked to participate in this panel and why I quickly agreed. Despite my lack of grounding in the discipline of legislation. Yes, I was in the Law Commission, but no, I have no real technical knowledge of other rules relating to legislation from I guess, a teaching point of view. But my joy at participating comes, in fact, from the realization that something that's been dragging on for quite a while and then peaked and waned, is coming back onto the radar, as it were, and that is the issue of legislation and customary law. When I began to read for this engagement, I realized I had, in fact, regularly raised my concerns in the past, sometimes obliquely, sometimes quite directly. And in all of those instances, my worry was always that there was something not quite right about the way we went about enacting laws around customary law, even though I could not put my finger on where the defects lay. So I am excited because this panel at least gives an opportunity to realize that things have changed quite significantly over the last while, and that we have more to work with today than even just 5 years ago. I take 5 years because that was 2017, and I voiced again my concerns about customary law and what it was losing in the process of legislation, particularly in a 2017 SAJHR article on customary law, that some of you may remember, on customary law and what I called at the time constitutional confrontations in culture, gender, and living law. So I'm very pleased at this improved environment. And it appears to have been brought about by judicial developments, in particular, the decision, of course, in Gongqose, which I am even happier to say will receive thorough attention this afternoon from my colleagues on this very panel, making it unnecessary for me to do more than simply mention the case. But what it does mean is that having confessed my weaknesses in the area, I can at least benefit from the work of my colleagues when I attempt to tease out what has been troubling me in the past and perhaps do this to better purpose this time around. I thus heartily acknowledge my indebtedness to the analysis by Michael Bishop on the Gongqose decision that you'll hear about and some of its implications for legislating customary law. I am equally indebted and very happy to have had similar discussions or discussions on the same matters with Vermeer. And so I really do want to record my indebtedness to these two colleagues in particular, because a lot of what I'm going to say next takes into account the fact, or takes as read the fact that between the two of them, they've been grappling with this area for some time. Aware of the constraints of time, my starting point will thus be a very brief summary of what I have taken from these interactions with colleagues, but particularly also from a reread for the umpteenth time of the paper by Michael, Asserting Customary Fishing Rights in South Africa. It's about fishing, but it's very rich in also the issues that one has been worrying about. I have sort of put together a list of what I think I am getting out of this. And just to start us off, it's got 9 points, and it is basically what I consider to be now, today, the accepted position of customary law, I was going to say, but perhaps the accepted position and also some academic debates around legislating customary law, which have been raised by recent events such as the Gongqose decisions. The 9 points I find fit this attempt are as follows. One, of course, that is clear, customary law is recognized. We know that from section 11 to 211.3 of the Constitution. 2, it is subject to the Constitution. We also know this from that section and also from cases like Ben, Shilubane, Alesco. 3, it is subject also, in addition to the Constitution, to any legislation that deals specifically with customary law. And this is important. It is also very ably dealt with in Michael's paper. 4, customary law may be regulated in addition by other legislation. We get this from section 212 of the Constitution. 5, the version applied in South African law is in South Africa is living, of course, not official customary law. You know this. 6, it is an independent source of law on a par with common law and legislation. Again, I think we are all aware of the authority for those propositions. 7, it can be justified under the culture and equality provisions of the Constitution. 8, where it exists, there is no further need for regulation. In fact, the way I wrote this down, and I think it is important, is that where it exists, there is what Vermeer calls theoretically no need for further regulation. And that's accurate, because there might be need for it to align the customary law rule or principle with the Constitution or for any other legitimate purpose. We get this among other pointers. Section 39, subsection 3 of the Constitution, the little known one, or the one we speak not as much about as the one before it, 39.2, of course, about bringing in the spirit and purport of the Bill of Rights to everything that the courts do. But 39.3 is the starting point for saying where customary law does exist and it does not violate the Constitution, then everything is fine. It is not barred from operating. And finally, my point 9 was that if it is interfered with for purposes other than the above, namely to bring it in line with the Constitution or for any other legitimate purpose, then such a limit, and in that way limits, or in doing so limits or alters rights held under customary law, then such limitation, as Michael makes very clear in his paper, must be justified under Section 36 of the Constitution, the limitation clause. And you will recall that that clause requires Parliament to apply its mind to the nature of the right, the purpose of the limitation and its importance, the nature and extent of the limitation. Third, fourth, whether the limitation will achieve the stated purpose, and five, whether there is a less intrusive way to achieve the same purpose. That's, I wish we had time, but I hope there will be during the discussion. A point that always interested me, although I'm not quite sure if I'm getting it right. I do recall that the dissenting judgment in Bear versus Magistrate Kailicha of Justice Mlobo went into this quite a bit, and I would be interested in discussion time to find out something that will build me up and make me feel a bit more confident about this that I believe in so much, which is that...
Professor Nhlapo, 5 minutes
yes,
left. 5 minutes left. 5 minutes?
Really?
Yes.
And so what this implies is that the legislator should understand customary law that it seeks to regulate, so as to be able to use the living law as a starting point, and thereby, among other requirements, to find the least intrusive way of intervening in it. My own musings about what can go wrong with legislation, I'll just rattle through them quickly, is of course, firstly, the misunderstanding of the implications of Section 211.3, when it says customary law is recognized but is subject to laws in addition to the Constitution, dealing specifically with it. More specifically, even for Section 211.3 legislation, as Michael calls it, that does aim to deal specifically with customary law, there are certain misunderstandings that do occur. The big one for me is one that was very prevalent in the early debates, early and later debates on the traditional courts bill. And it is the sort of misinformation, as it were, that ACL is only, the African customary law, is only constitutionally valid if it has been regulated in terms of legislation or codified. It's a prevalent view. At the proper time, we may talk a little more about it, like, for instance, the statement by the Department of Justice in 2012, talking about the TCB. But even when it is mandated and it aims to be about specifically dealing with customary law, it must not extinguish customary rights. Michael, again, in his excellent paper, it does deal quite a bit with rights versus simply customary practices, what is protected, what is not. Because if it does extinguish or alter such rights, then the Section 36 requirements must come into play. There's a point that I'm interested in, and it's this next one, that in addition to these technical legal issues, there is, of course, as far as what can go wrong with legislation is concerned, just parliamentary practice. I think our current parliament has a very bad consultation culture, and that must come in surely in reckoning issues around legislation. Tungwane, for instance, and other cases have been struck down, not necessarily on the merits that were first proposed, but on the fact that the process that Parliament followed was so bad. The act should be struck down. But some examples, and I think that is why I was brought here. It's a pity, or invited here. It's a pity that it's now the last minute. But on the Recognition of Customary Marriages Act, for instance, it is very clear that Section 7, subsection 6 is problematic. That is the one that tried to contain polygamy, but via a totally impractical expectation that people in traditional life will understand, let alone comply with the elaborate legal processes that were proposed. There is Section 8, which is a worry, because again, coming from a good place and based on noble intentions, the issue of termination, it was moved to a court on the basis of the common law found that informed Section 9 of the Divorce Act, ousting indigenous termination processes and settling us, alas, with what some have called twilight marriages, where customary couples consider themselves divorced when in fact they haven't been to court and so therefore are still married, bringing in a flood of problems. The Reform of Customary Law of Succession Act, I will quickly tell you about where you can find some more really serious and well thought out criticism of some of the things that have happened. But it has been argued, if you recall, that Bear, for instance, could have been decided on the basis of preserving the deep cultural and communitarian reasons for primogeniture, untainted by or sanitized of official law distortion, while encouraging the development of a version that does not violate the Constitution. I have a PhD, a doctoral thesis by one Dial Ndima that I will talk about at discussion time, that is really quite an excellent guide as to what went wrong with the legislature taking over this order from the case of Bear, and basically making a mess of it by making permanent what? 1 minute.
1 minute left, yes.
Yeah, making a mess of what the court had intended to be interim recourse to the Interstate Succession Act and making that permanent. There's a lot to say about that. Let me just end it by saying that you can read this thesis I'm talking about, where Ndima makes it very clear how implausible and impractical the notion of a child's portion, for instance, is to a villager in the Eastern Cape. The traditional courts bill needs no introduction. You recall from its 2008 version and the slew of cosmetic amendments following it. It has suffered a lot of chronic defects apart from the opt-out clause. One may conclude this by saying that in most of these efforts to regulate customary law by legislation, Parliament tramples over mainly customary rights. Secondly, that the current post-Gongqose period affords a welcome opportunity to revisit the proposition that the starting point of intervening legislatively in respect of customary law should be the very customary law that is sought to be amended or regulated. This is not to retard necessary change. It's simply to pursue change in a way that tries to protect the protections afforded to customary law by the Constitution. And ending on a positive note, I do believe that the technical legal tools now available to the reformer have been increased by the recent judicial decisions we've been discussing, and that from now on, maybe the mindset will change when we attempt to intervene in customary law by legislative methods. Thank you.
Thank you very, very much, Professor Nhlapo. That was great. I'm now going to just give 5 minutes maximum to the venues for translation. So we will pause here online and wait for translations in the venues and then come back and Michael will be next.
Shall we go off the screen there? Me?
You are allowed to go off the screen. Yes, thank you.
molaong na molao o di o be molaong ka mogore di ya melao ka gona ka setšo ka setlwaedi sa rena then mo leng gore o re o na le ntlha tše senyane nka se di bolele ka moka go bolela ka gore molao o dirwe o be molaong ke tshwantse gore di lebelelwe e kgolo ke gore se ka ba go ba le kgatakelo ya molaotheo and then le gore molao mo lo mongwe go dirwa o tshwanetse gore go be le molao wa semolao o le go dirwa ke palamente o leng gore o a o thekga ene go be le ditsela-tselana tša gore o laole tshepedišo gore na molao o dilo di tlo sepela jwang ke mo go bolela ka ditaba tša dikgorotsheko le gore go na le dithulano ba dikgotlhano bolamodi bo tlo sepela jwang jwalo ene wona molao wa setšo ba re o tshwanetse gore o be le tokelo ya go ikemela o se ka khumana re o ema ka molao mongwe ke nagana re e tswalana le ele ya maabane ya gore re lebelele gore na go ka kgonagala gore re nyalantšhe common law le customary law na then ge le re ya di nyalantšha principle ye ya o ikemela e tlo šala e kae o tshwaswaile gape le taba ya gore go na le ditlamorago tše dingwe tše e leng gore di a bontšha gore ge re lebelela go laofatša molao wa setšo re tshwanetse gore di lebelele kudu re lebeletse molaotheo wa Afrika Borwa ko karolaneng ya bo 211 subsection 2 le subsection 3 gape le wona molaotheo ko subsection ke 36 le yona re bona na ga tsakelwe na a re kudu go ka lebelela go njwele dipolelo tše di beng gona mabapi le molao kakanywa ola wa go lagola dikgoro tša ditšhaba ka boripana di bitša TCP o ka e lebelela e na le ditaba tše e leng gore tše dingwe go na le go tlhokega go ntse ka mogare ga tšone.
Sien, I cannot see the breakout rooms on my screen, so can you give an indication of when they're done or when we can go ahead?
Mo leng gore ge re lebeletše ka ona molao kakanywa ola ditaba tše e leng gore di na le go se tšwele nyanyeng tše dingwe tša tšone ke tša gore o khumana le gore o gata kwa ditokelo molao kakanywa go šetše o bontšha gore go tlo gata kwa ditokelo tša batho tša gore motho a ka ikgogela morago le gore motho a be le ditokelo gora gore ditokelo ka botšona šetše di bontšha gore motho mongwe le mongwe di tlo gatakwa mo leng gore go lebeletse dintlha tše dingwe tša ona molao kakanywa ola ntlha ya botshelela ya bošupa le ya bosenyane
Is London done?
le tšona di ba le bothatanyana. Thank you. Ke nagana mara le ikwele kere e tlhapile kere ka omo.
Okay, we can move on to the next speaker.
That's great. Thank you very much. So our next speaker is Michael Bishop, who was already kind of introduced by Professor Nhlapo. I should say he was inadvertently promoted on the program to senior counsel. He didn't do that, but when you see him, you'll realize it's unlikely. It's just a matter of time. Michael, over to you.
Thanks very much, Vilmeen, and thanks to Prof. Nhlapo for the very kind words about my paper. I feel that he set the expectations very high, so I hope I live up to them. I'm going to talk about how people can assert customary law rights when there is a statute that purports to regulate the same area, whether that's fishing or land or customary governance. And it's really a talk about section 211(3) of the Constitution, which enshrines customary law subject only to the Constitution and legislation that specifically deals with customary law. And so the paper is really trying to figure out, what does specifically deals mean? How do we know legislation that specifically deals with customary law? And how do we know what the effects of those types of law are on the customary law? And the bottom line really is that customary law continues to exist, notwithstanding legislation that may regulate the same issue, unless the legislation is legislation that specifically deals with it, with customary law. So that must be legislation where the Parliament has considered the impact of the legislation on customary law. And even then, the customary law continues to exist unless there is an express extinguishment of the customary law right. So you've got to always try and keep the customary law rights and the legislation together, rather than treating legislation as an automatic trump of customary law rights. And the example that I use, as Prof. Nhlapo mentioned, is the Gongqose case, but it's really, which is about fishing rights. But it's really just an example. So it's where sort of 211(3) first came in as a sort of came into its own in the courts. But the principles apply to other contexts as well, whether it's mining rights, land rights, any sort of resource rights, or customary governance issues. So I'm going to start with a brief description of Gongqose, just for those who don't know about the case, and then set out sort of what I think are the steps of the analysis when you're dealing with this type of problem, and then go through some of those steps in a bit more detail and try and deal with some of the more difficult or interesting issues. So what happened in Gongqose is that there were 3 fishers who were arrested for fishing in the Dwese marine protected area, which was also on land that was owned by the community of which they were a part, which they had claimed in a successful restitution claim. And they were arrested because there was a law at the time, section 43 of the Marine Living Resources Act, that prohibited any fishing within a marine protected area. So a marine protected area is established for environmental reasons. And this was an unusual one. It was a no-take marine protected area. So absolutely no fishing was permitted in the area. So they were arrested for breaching this law, but they argued that even though there was a statute that said no fishing, they were allowed to fish because they had a customary law right to fish. And the legislation, although it prohibited fishing, hadn't abolished that existing customary law right of theirs. And they established in a trial in the magistrate's court, the transcript of which is fantastic, but unfortunately I don't have time to go into it, but it's very entertaining. But they established that they had a customary law right to fish in the reserve, but both the magistrate's court and the High Court held that that didn't matter because the statutory prohibition effectively trumped their customary law right. And we took the case up to the Supreme Court of Appeal, where we won. And basically what the Supreme Court of Appeal found is that the key finding of the Supreme Court of Appeal was, I'm going to quote now, first, a customary law right can only be extinguished by legislation specifically dealing with customary law. And secondly, that such legislation must do so either expressly or by necessary implication. So here, there was a customary law right to fish. You had the section of the MLRA, but it wasn't legislation that dealt with customary law. There's nothing in the MLRA as it existed at the time. It's been amended since, and I'll deal with that. But at the time, it didn't mention customary law at all. So it wasn't a 2113 law, so it couldn't affect the existing customary law rights. So the fisher's conduct was lawful, even in the face of a apparent statutory prohibition. So it's a very good example of how customary law continues to exist and continues to afford people real legal rights and protections, even in the face of legislation that purports to prohibit or regulate the same conduct. So if we, the next part of the talk is to think, based on what was said in Gongqose, what does that mean for analyzing similar types of claims in the future? And I often say that Gongqose was an easy case because what it had to do is establish the principles, but it was actually a very clean case because there was no debate that these fishers had customary law rights. And there was no debate that the MLRA was not a Section 2113 law. And what made it easier from a practical perspective is it actually had very little prospective consequences because the law had since been amended. So the court didn't have to worry that suddenly it was going to make fishing lawful everywhere for people asserting customary law rights because the legislation had been changed. And I should stress before I talk about what I think the stages are, that there's a difference between asserting a customary law right and relying on a cultural practice. So not all cultural practices are also customary law rights. Cultural practices have constitutional protection under Section 30 and 31 of the Constitution. But what I'm really concerned about for the purposes of this talk is rights that have a legal basis that are recognized as customary law in the Constitution. And Prof. Mhlapho talked about Section 39.3 and Section 211.3 that recognize them as an independent source of law. So I say there are 5 stages to determine whether, when you have legislation that seems to regulate the same area, whether we're talking about the Mineral Petroleum Resources Development Act or the Traditional and Khoisan Leadership Act or the Marine Living Resources Act, to see how they impact, limit, or abolish a customary law right. So the first question is there a customary law right? If there is a customary law right, the next question is this a statute that meets the requirement of Section 2113? Does it specifically deal with customary law? The third question is, if it is such legislation, because if it isn't, that's the end. The customary law right remains enforced and can be exercised. But if it is Section 2113 legislation, how does it affect the exercise of the customary law right? Because it doesn't follow merely because it's 2113 legislation that it now supplants, replaces, abolishes the customary law. You have to look at what is it actually doing to the customary law rights. So that's the third question. The fourth question is, if this law, this 2113 law, does limit the exercise of the right in any way, does that limit a right in the Bill of Rights? And it ordinarily will limit at least Section 30 and 31, but there may be other rights as well. And finally, if there is a limitation, is the limitation justifiable under Section 36(1) of the Constitution? I'm going to focus today on the first 3 stages because the last 2 are more sort of traditional Bill of Rights analysis. And I think the more interesting questions are in the first 3. So the first question is there a customary law right? And how do we establish whether there's a customary law right? In Gongqose, detailed evidence was led both by at this time, I suppose they were the accused people, and by experts that they called, to establish that what they were doing when they were fishing was not just fishing as a practice, but fishing as the exercise of a right that they had as part of a community governed by customary law. And there was not really, by the time at least it got to the High Court and the SCA, not really any dispute about that. But there will be cases where it is disputed. So what are the requirements to establish a customary law right for these purposes? And I've suggested that there are 3 requirements. There may well be more or less. I'd be very interested to hear people's views. But the first requirement, I think, is that the community must practice and be bound by a system of customary law. So what that means is that it can't just be asserting customary law only in, for example, fishing. There must be things beyond this particular practice where the community regulates itself according to a system of law, not just that they have rules about how to engage in one particular practice, whether that's fishing or hunting or any type of other use of resources. So that's the first requirement. The second requirement is whatever the issue is, the right that you're trying to assert, whether that's access to land or access to marine resources, there must be...
5 minutes left.
Thanks. There must be rules or regulations that regulate how that can be done. So there can be rules about who, in Gongqose, for example, the rules were about when you can fish, where you can fish, how you can fish. And the third requirement is that if it's asserted by an individual, the person must show they're a member of this community. The right may also be asserted on a communal basis, but if it's asserted by an individual, it must be asserted by a member. So once you've established this customary law right, the next question is, there's this law, is it a Section 2113 law? And again, in Gongqose, that was an easy question because just the Act didn't mention customary law at all. But what is the standard? What does specifically deals mean? And I thought it helps to think, well, why does the Constitution have that requirement? Because it's different than it is for the common law. There's an assumption when you're comparing legislation and the common law that the legislator knows what the common law is. So if there's any conflict, the legislation will trump the common law. But that's not the case for customary law because of 2113. And I've suggested there's two reasons. The first is that it's actually meant to afford customary law a special status and recognition, particularly because of its history of denigration and non-recognition. And secondly, an assumption that it's not, or it doesn't always make sense to assume that the legislature knows what the customary law is. It's an assumption that might make sense for common law, but doesn't for customary law. So I think that there are two requirements that have to be met for a law to be a 2113 law. And they have to appear from the law itself. They can't appear from other documents. They must appear from the law. The first is that the legislator knew that the law could affect customary law rights. And secondly, that the legislature took a decision about how this statute would affect the customary law rights. And if that doesn't appear from the law, then it's not a 2113 law, and it can't interfere with existing customary law rights. So some statutes are easy, like the Recognition of Customary Marriages Act clearly is a 2113 law. Some are more complicated. So the Post-Amendment Marine Living Resources Act now allows small-scale fishing, and it defines small-scale fishing communities with reference to customary law. So customary communities can now, there is a mechanism for them to fish and obtain fishing, well, exercise fishing rights through the Marine Living Resources Act. So I think that is a 2113 law. But it would never be enough just to have a section in the law that says, to the extent there's any deviation between this law and customary law, this act prevails. That wouldn't be enough because you haven't actually dealt with it. You've just tried to create an automatic trump without any engagement with what the content of customary law is, or whether or how it should be altered, extinguished, and so on. So even if you meet that test and there is now a 2113 law, the next question is, well, how does that affect the customary rights at issue? And there's different options. You could have legislation that expressly extinguishes the right. It says all customary law rights to fish are hereby abolished, right? Or you could have a customary legislation that alters the rights. It says all customary law rights to fish must now be subject to the regulations to be passed by the minister, or it could seek to regulate them in some other type of way. And these aren't mutually exclusive. You could do all of them in one statute, or you can do a bit of each. But those are sort of the main ways that legislation can try and impact on customary law. But the important point, and I think this is really one of the keys in Gongqose as well, is that the fact that the statute, what the statute envisages is different from what the customary law envisages, isn't extinguishment. So what the SCA said is you only extinguish if it says it expressly or by necessary implication. That means there's no other possible way to read the law other than an extinguishment of the customary law rights. And I've always found there's a statement in an Australian High Court decision about hunting juvenile crocodiles, where they say that regulating the way in which a right may be exercised presupposes that the right exists. So when you're regulating customary fishing, you're still assuming that the customary fishing rights exist, and you're deciding how to regulate them. So how this plays out can be a bit difficult. So if we take the MLRA again as an example, it now says if you want to fish as a small-scale fisher or small-scale fishing community, you must have obtained a right under the Act and you must have a permit under the Act to exercise that right. So what does that mean? Does that mean that customary communities who have customary rights now lose those rights and are relying only on the statutory rights? So unless they get the statutory right, they have no right at all. I don't think that's what it means. I think what it means is one of two things.
1 minute left. 1 minute.
I'm almost done, thanks. It either means that the minister is obliged to recognize rights of customary communities that have customary law rights. So you have different small-scale fishing communities. Some of them have a practice of small-scale fishing, but don't have customary law rights. Others have customary law rights. If they have a customary law right, the minister is obliged to grant the statutory right and to grant the permit. And the minister doesn't really have a choice in it. And then she can regulate through the grant of rights and permits how the fishing occurs, when, where, what times, those sort of things. But that's the limit of her powers. The other option is to say, actually, the fishers are entitled to continue to fish, and that the power for the minister to grant rights and permits is an optional power that she can choose to use. But if she doesn't, the customary law rights continue to exist. But either way, they're not supplanted. So I'll end there. And just, in conclusion, I think really the importance of Gongqose and Section 2113 is to provide powerful procedural protections to ensure that whenever Parliament legislates on issues that are that affect customary law, that they have to actually engage with the content of customary law and think very carefully about how they want to impact on it. If they don't do that, then they can't affect customary law. They can't limit its exercise in any way. Thank you very much.
Thanks very much, Michael. That was great. I'm again going to pause for 5 minutes for translation in the different venues, and then we'll be back, and Jackie and I have a paper complementing Michael's to tell you the story further.
Yeah, presentation e very lebeletse mo e be sa e tswetsa pele gore ka re kwelo re gona le mekgwa e be re phela ka yona. So se a se bontšitše go mola o reng molao wa customary ge re berekana le ona go nyaka gore melao ye mengwe e kore o se wa go berekana le ona ka molao o mongwe o se wa dirang o bereka o le noši akere. So ge go na le ditokelo tše e le gore batho gala ba ipsina ka tsona pele ge ba go tlotla mo e leng gore batho ba le ba tlo tšeela ditokelo tšeo go nyaka e le gore go na le molao o fetošitšego go ya ka mo setšo sa batho se be se le ka gona. O file mohlala mo a reng go ile wa ba le case nngwe e le gore ba ile ba swarang barei ba ditlhapi ba bararo ge ba seno ba swara ba ba swere ka lebaka la goreng ba ba hweditše ba rea ditlhapi lefelong le e leng gore go ileditšwe gore no mo a wa swanela gore wa ditlhapi. And then molato o khotho ya mathomo ba ile ba lahlegela ge ba dira appeal go raka godimo ya lebela ya re no mara batho ba pele ga molawana wa dimarine o tswelela batho ba gale ba na le tokelo ya go dirang ya go rea ditlhapi lefelong leo. So ka gona molawana o moswa o fitlhilego o paletše ke go lebelela gore batho ba pele re ntšha molao o moswa ba na leng le ditokelo. So go ra gore gona go na leng go se ke wa ba le molato and then ba kgona go dira ba kgona go tswa ga ona. So e nngwe gape ntlha a gonneng go e bontšha ke ya gore ge re tla mo tabeng ya customary tokelo tše batho ba ipsina ka tsona ba na le tsona di swanetše gore ge di fokotše ke molao o leng gore o beilwe o amana leng le taba tšela tšang tša gore ba phela jwang gore go berekana le ka mokgwa batho ba phela ka gona ga o no itšea wa berekana le yona e le noši. And then I want to know, can
we have someone else that is just trying to share the presentation right now? Kiara, this is your presentation. Which page should we be on?
All right. So,
thank you.
bjalo rena ditokelo tse re ka kgona go di hwetša jwang a re no setšhaba se swanetše gore se direng se itireleng melao ya tsona. And then ge ba mo ba dulang gona ke taba ke felo e leng gore go na le diphoofolo ba nyaka go tsoma gore ba nyaka go rea ditlhapi ba santse ba tengwalele gore na kana go tsoma mola re tsoma sejwang ditlhapi tše le ge re ya go di rea re rea tše kae ka nako mang. And then ye nngwe gape e bontšhitšeng gore ke bohlokwa and ke ya goreng gane jale ba fele ministera maatla a goreng kua batho ba le ba dulang kgausi le mawatle ge ba ya go rea ditlhapi ka gore le tokelo ya bona ba santse gore ba direng ba dira dikgopelo ba be le sela ba se bitsang gore ke itumelelo permit.
We are still a minute or so
and taba ya
for
tumelelo
translations.
mola o bontšhitše goreng
In the meantime, I can tell the person in the chat that Michael, the question is, what is the title of your PhD?
Abandoned so that I could go to work for the LRC.
Best life choice. Can I get an indication from the venues when they're wrapping up? Thanks. Okay, I see Durban is done. East London, Johannesburg.
East London is done, Wilmien.
Thank you. Johannesburg. Okay, I'm going to assume that Johannesburg is wrapping up. And in the meantime, introduce myself.
We are done.
Sunday,
We are
down. The
down.
next paper, and we can at least get our presentation going, if that is in order. So I'm Wilmien Wickham. I'm from the Legal Resources Centre, and my co-presenter, the person with whom I wrote the paper, is Jackie Sandi. She's next to me, Dr. Jackie Sandi.
Hi, yes, I'm Jackie Sandi. I'm based at the University of Cape Town in the One Ocean Hub research team. Thanks, Wilmien.
Thank you, Jackie. So I'm just going to pull up our presentation, which nicely, I hope, complements Michael's this afternoon. There we go. Jackie and I this afternoon are going to talk about what's happened after Gongqose, I suppose. Well, before and after Gongqose, and kind of the promise of Gongqose. To what extent did it bring the changes that we had hoped? So we're just sharing a couple of pictures, because you've heard a lot about Dwesa now, and now you can see where it is. That is Mr. Gongqose in front of the Elliotdale Magistrates Court, and you'll see where Dwesa is located in South Africa, and the mussel harvesters and fishers of the area. And we also quickly wanted to show you Cozy Bay, which Pelide spoke about it yesterday. So this is another very good example of customary fishers in KZN in South Africa. So as Michael finished, he talked about this important contribution of Gongqose as the one to force the legislature to directly engage with customary law. And this is incredibly important. I want to relate it to what Advocate Nkatobi said yesterday, and lots of people picked up on, which is law is made by the people, not by politicians. And we must start forcing bottom-up legislative processes. And the judgment says exactly that. It says for the legislature to regulate customary law, it must understand what's going on there on the ground. And I mean, I went back to older submissions of ours. It's not a new idea. We've been telling Parliament this, as Professor Nhlapo also mentioned, for at least a decade. And so with the Traditional Courts Bill, for example, just the message that how on earth can you say you are regulating something if you don't even know what is happening on the ground? So it's important to understand the context of Gongqose. So while the Dwesa fishers' struggle for their customary fishing rights was ongoing, in parallel to that, there was a struggle by small-scale fishing communities across South Africa, the entire South African coastline. Some of them, certainly in Eastern Cape and KZN, are customary communities with customary fishing rights. Many others are not customary in nature, certainly traditional fishers and traditional coastal communities, but without customary systems, in particular in the Western Cape and the Northern Cape. But all of them were excluded from the MLRA. Initially, they went to the Equality Court, and as a result of that, small-scale fishing communities had to be recognized. It was based on their right to food security, their right to equality, etc. So that process of recognizing small-scale fishers or communities started much earlier. And in 2012, while we were negotiating this policy, we told the department, now this is 4 years before Gongqose was in the SCA, no, 6 years before. So we told the department, look, there are people with customary fishing rights in South Africa, and you better put that in this policy, and you better start understanding how to find and recognize and regulate those rights. At the time, the department told us in a legal opinion that, and I think they may have misread Mahmoud Mandami, saying we must differentiate between law established by custom and customary law, and our clients might have the former, which is not to be recognized. And secondly, they also said, and this is important, people must prove that they have customary systems of law, with which we agreed. So they were against the idea, but we did get wording, language about customary law into that small-scale policy, which we were very excited about, but I think we've learned that it doesn't really help to get wording into legislation or policies if the department doesn't understand what it means. But I've put some of it on the slide there. So then in 2014, the Marine Living Resources Act had to be amended to incorporate small-scale fishers. And this is what Michael was referring to when he said Gongqose was an easy case, in the sense that the MLRA had already been amended by the time it got to the SCA. So we very naively took this opportunity to go to great lengths to help the legislature, we thought, in coming up with mechanisms as to how they can start going to the ground, finding, recognizing customary rights, and on that basis deciding how to regulate them. And we said to the legislature and the department, this will require a paradigm shift. You can't just tack on these rights to your existing way of doing things. You need to start thinking in a completely different way if you're going to recognize customary rights in the right way. We drew a lot on the international experience to do that, and I'm going to ask Jackie to talk to that.
Thanks, Philmin. So, skip that. Okay, Philmin will come back to this. So just thinking about some of the lessons that really have emerged from international experience. I mean, it's very obvious that many post-colonial states have really grappled with this issue of how to recognize customary fishing rights, in some countries, customary marine tenure, in context of legal pluralism. And we see a range of strategies and experiences. It's constantly evolving, but many countries have in fact grappled with this issue of how do you infuse the best of customary law and amalgamate customary law with statutory law and develop hybrid systems of fisheries management. But notably in contrast to South Africa, most countries' recognition of customary fisheries is integrated with adjacent land tenure systems. So in the context of this conference, I think it's very interesting to see how in many countries, they've had rights inquiries that have both looked at land rights and looked at the adjacent customary fishing rights or marine tenure rights. So for example, even in Australia, they actually refer to Aboriginal Sea Country, which I think really shows that very integrated approach. And most jurisdictions provide for clear recognition in statute, but also then separate regulations for customary rights. But again, coming back to what Michael has emphasized and Vilmin, emphasizing the need to understand the customary system and to start from that point. So an example from the South Pacific, in Fiji, as early as 1942, in the Fisheries Act, had a clause protecting native customary rights, establishing a fisheries commission, and then setting out the procedures whereby the commission could begin a rights inquiry and looking into what these rights mean for people on the ground and working from that point upwards. Over the last sort of 2-3 decades, we've also seen, obviously, in international law and policy instruments, increased and heightened awareness of the importance of recognizing customary systems and then giving guidance on how one might go about these processes of recognizing and understanding them. I won't go into detail because of time, but particularly from the Convention on Biological Diversity, there's been incredibly good guidance coming out on the importance of recognizing customary fishing rights, and interestingly, including the detail of needing to actually recognize Indigenous communities' rights and their responsibilities that come out of their customary systems. And in this instance, obviously, the customary obligation to protect their commons and their collectively held natural resources. We also have seen since 2007 with the UN Declaration on the Rights of Indigenous Peoples, which clearly says that states should establish and implement in conjunction with Indigenous peoples a fair and independent, impartial and open, transparent process to enable their rights to be recognized. But I think for the purposes of this conference, what's particularly useful for us is the voluntary guidelines on tenure that emerged from the FAO in 2012, which has set out a very clear process for recognizing, respecting and protecting all forms of legitimate tenure rights, taking into account, where appropriate, customary rights. And again, this issue of the interconnected relationships between land, fisheries and forests and other natural resources is really emphasized in the VG tenure. So just some of the steps that are set out in the VG tenure: states must first identify all of these existing tenure rights and rights holders, whether recorded or not. They must then provide support to tenure holders so that they can enjoy and fulfill their rights. They should ensure coordination between implementing agencies, publicize the categories of these rights, establish safeguards, and where it's not possible to provide legal recognition of tenure rights, prevent enforced evictions that are inconsistent with existing obligations under national and international law, and provide access to justice. Fortunately for Wilmin and myself and others working in the area of fisheries and marine tenure, the small-scale fisheries guidelines that came out in 2014 grew very heavily on the VG tenure. But two important issues that I think to emphasize from the small-scale fisheries guidelines is that they recognize that communities' own decision-making processes within their communities must be recognized. So it's not just about recognizing the fishing rights, but actually recognizing their decision-making. And that's important in terms of how you involve them then in fisheries management. And then importantly, and I think in the South African context, it's critical, the VG small-scale fisheries guidelines say it's really important that the legislation starts from the point of understanding the customary fishing rights in their own setting and in their own context. I'm going to pass back to Wilmin.
Thanks, Jackie. So with all those wonderful background, we presented our dream piece of legislation to the legislature and the department at the time. Of course, in reality, it looked very, very different. So that Amendment Act that was then passed did not say anything about customary law and how to recognize it. The only reference we could slip in was a reference to Section 39(3) of the Constitution, which everyone has mentioned. And then, so the new act now included small-scale fishers, and it talked in the definition of small-scale fishers, there was reference to shared rules and so on. And so, from the department has since argued that that is the recognition of customary law. Well, we'll see how that is played out. Now, the rollout of the recognition of the small-scale communities has been a complete disaster. The department reverted entirely back to individual applications. The whole notion of the community who can verify and regulate the kind of local management idea was all out the window. There were some arbitrary rules, like if a community doesn't have at least 20, a community of fishers don't have at least 20 members, they're lumped together with their neighbors, even if the neighbors are 4 hours up the road, etc. So the rollouts certainly did not speak to a department that understood the challenge of understanding customary law. There's also absolutely no differentiation in how they treat small-scale communities that are not customary and those that are. And perhaps the best illustration, I think, of a regulator in Pretoria writing regulations without the faintest idea of what is happening on the ground would be the regulations that was passed after the Gongqose judgment to open the Dwesa MPA, as Michael mentioned. So these regulations were published in 2016, opened the MPA up for both small-scale and recreational fishers. So Dwesa Twebe, I must tell you, is a huge area. It takes about 3 hours drive from Dwesa to Twebe. If you have a car, which no one there does, it's officially the poorest district in South Africa. So people don't have airtime. There's no communication. You don't see even the other members of your village. It's actually 7 widely spread out villages. So that's the reality on the ground. And yet somehow the regulation said that these hundreds of fishers must every day decide which 39 of them will go to sea, and they must alert the Parks Board by 12 o'clock who the 39 will be. It also put on a blanket daily limit of 30 mussels. So women live off mussels and they feed their families off them. If only 39 fishers can go to sea in a day, that'll mean a woman is lucky if she can go once a month. She can then take 30 mussels, which is maybe enough to feed one very small family for one meal. And the rest of the month, it is unclear what they were supposed to do. Most of the species that was listed that they were allowed to fish for was not available in Dwesa Twebe. So really, this is an illustration of what happens when you regulate or legislate without the faintest idea of what is happening on the ground. Government's position, unfortunately, has been one, this is based on a legal opinion, that the Gongqose judgment only applies in Dwesa Twebe and has no implications on any other community, which is, they would be astounded that there's an entire panel speaking about this judgment today, because in their minds, it's of absolutely no consequence. And they believe that the fact that they have now recognized small-scale fishers means that they have dealt with customary rights. So to end off with some questions and further developments and what we've learned. First of all, the interesting question of why customary fishing rights are treated so differently to land rights, customary land rights in South Africa. And, you know, I think it's probably got a lot to do with the fact that the minister is the custodian of the ocean and is supposedly the one with the exclusive right of deciding who can fish. But it's interesting to compare that to Tembeka's comments yesterday about really the state wanting to be in control of customary land rights and also still wanting to be in control of that, and that is also what they're doing there.
You mean 1 minute left?
Thank you. So secondly, I think what's been a great frustration for us, and maybe our frustration is clear, is that what we've really been trying to communicate to the department in particular, who has the tough job of deciding who gets a fishing right and who doesn't, is that we want to give you a solid legal basis for giving fishing rights to some people for a pro-poor approach, which can help you resist all the corporate attacks, because they, of course, want all the fish. The government doesn't see it that way, and so they keep taking political decisions. Thirdly, very quickly, just to say that an interesting development since Gongqose has been the Shell litigation. Jackie spoke about customary law not only providing for rights to the ocean, but also responsibility for the commons. And in the Shell litigation, those arguments were being brought by the same Dwesa Twebe clients, broadening some of the arguments that they had made before. And I'm going to ask Jackie to finish up.
Okay, thanks, Philomene. So just some of the lessons that have sort of emerged is really this emphasis on the need for a procedural sort of approach, identifying the principles and not trying to codify customary law. We realize from lessons elsewhere, it takes a very long time, as fisher communities must be supported and enabled to articulate their systems of rules and practices. And the state and its officials must understand the system in its context, in its own setting. And that efforts must be made to support fishers in articulating the underlying principles and values in their own system. And then how these might speak to statutory principles, many of them in the Constitution, such as sustainability and that the state in consultation with the communities would then identify the outcomes, at the end of fishing, what must be the outcome? Yes, there must be a sustainable outcome, but each customary system should be allowed to identify the pathway that they are going to take to achieve that outcome. Principles such as subsidiarity, socially embeddedness, flexible changing, and the living nature of customary law really must be acknowledged, and also an ecosystems-based approach that highlights the linkages between land and sea. Thank you.
Thank you. Thanks very much. That brings us to a close. I will allow 5 minutes again for translation, and then we'll have time for questions and comments.
Ka boripana paper ya bovelemina e be e tlaleletša godimo ga se Michael Bishop ba bolela ka sona go ira gore ke go aga go beya stena godimo ga foundation e be šetše e beilwe mo leng gore ba lebeletše ditaba tša go emana le barei ba ditlhapi ba ko Dwesaqebe mo leng gore taba kgolo ke gore ga go fiwe matlafatšo ya ditokelo tša barei ba ditlhapi re lebeletše melao ye ba phelang ka fase ga yona ka barei ya ditlhapi ka re molao wa mmušo wa go laola mafelo a e leng gore a šireleditšwe a ditlhapi o tlile o khumane batho ba ditše ba re ya ditlhapi mo leng gore setlamorago a ka se tle a ntšha mogologolo ka boripana then ge e fitlha mouwe le taba tšela tša gore ba tle ba dire molao ba swantše go lebelela gore na melao ye mengwe ya lefase ka bophara le meetlo ya go laola tša barei ba ditlhapi e sepela jwang ba bontšitše melao ka go fapafapana le tshepedišo ya ditaba ka go fapafapana na pele ge ba ya pele ba re go ne le selo se le gore mmušo wa Afrika Borwa o se dirile ene e bonala e le mathata e oketša ngalaba ya taba ye le gore šetše e le gona ko go bareng ba ditlhapi ba kua ba khumane barei ba ditlhapi e le dipalopalo tša go bonala mara ge ba fitlha ba re rena re nyaka gore re laole tshepedišo mo ene ge re e laola sa mathomo ko gore lena e peakanye le bone gore ke ba bakae ba 30 le ba senyane ba ile gore ka letšatši ba tla kgona go ya go rea ditlhapi batho ba ile gore ba phela ka tšona o ra re ke ba bakae ba ile gore ba tla kgetha gore bona ba sije na pele ge ya pele e re le be le re botse gore na ka letšatši le tshwara tše kae mara ge ba fetša ba beya seroto sa gore le ka se tshwara dikgaripana tša go feta tše 30 e ke re dikgaripana gore a ke tsebe leina la Sepedi la Mosele mara ko o tseba ko o lebeletše na pile ya re le ka se reye ditlhapi o ba le tšona dikgaripana tše bole ka se tshware gare ga go subela ga letšatši le go tlhaba ga lona ene re a tseba gore go rewa ga ditlhapi ke bošego ene ba tshwara tše dintšhi le tše di botse bošego e sentšela tša go contaminatiwa ke dipolotiki tša mmušo na pile ge ya pele e re ye nngwe ye ba e lebeletšeng ke gore case yela ya Gongqose ya bona batho ba Dwesaqebe a e ame fela ditaba tša Dwesaqebe fela e akaretša Afrika Borwa ka bophara ene go na le dipušo tše le gore ba di tšweletša mo ba rena goreng taba tša borea ditlhapi di sa tswalane le mabu le metsi ka re dilo tše bue ke di tsweletša tša tlhago ene ge re bolela ka molao wa go laola tshepedišo ya borena batho ba dutšewang ka re ba dula go naga go ra gore le tshwanetse gore re bone nyalano ya dilo tše bue le gore a re lebeleleng le gore re lebelele
take
tlhotlho ya
questions
semolao e re ka e
online.
diang e
You
leng
do
gore
so in
e
the
kgona go katološa
venues. So
taba tša
please,
customary rights rona re se ke
please do post your
ra di lebelela
questions
fela mo
in the
mabung
chat,
re tsentšhe le
and
di-components
we
tše
can
dingwe
deal
tša
with them.
di-common resources ke a leboga.
The Durban is done, so just waiting for Johannesburg. If I can then get an indication from the venues whether there are questions.
There are questions from East London.
Thank you. So I think shall we go over to East London? I think Joburg should be wrapping up, so we'll go over to East London for questions from there first. Thank you.
How many are you taking, Vilmi?
Can we have 2 questions, please?
Okay, perfect.
Oh, molweni. Sanibonani, dumelani, hello. Igama lami ngumthobeli uJomo Khuselo, ndisuka kumhlaba waseDwesacwebe. Ndifundile kakhulu ngoba lapha namhlanje. Just nina nguyimisa apha kukhomenta nofuna amacebo kwapha kovormeni. Ngaphambili ke basincede le case andiyithandabuza ndiyayazi. Sayiwina futhi siyaloba qha azisekhona ezinye ze-rights abasazifihlayo nanjengarhente ekhoyo phakathi kwethu elawula la marine protecting area wethu. Into endiyibonayo ngoku engumcelimngeni omkhulu engakafikelelwa esigqibeni sayo yinto yoba umhlaba kuyavakala uba ngowethu but kule workshop isuka la izolo ndifunde likhulu nento yoba xa ndiwisha laa nto yoba kuthiwa umhlaba ngowethu andiwufumani umhlaba ngowethu mna ndinguJomo. Ndiwufumana la mhlaba isengokarhulumente kuba i-Eastern Cape ngomnye womhlaba xa ujongile onozuthi awuphili South Africa ngumhlaba onemigaqo yawo yaphaya e-Eastern Cape ongafaniyo nowalapha ngeneno kwenciba uyoma ngeKapa okanye kwiDurban. So iyona nto ndiyirhalela kakhulu mna ndikwi-structure phaya ndikwi-executive ye-CPA yaphaya but asinamandla siyalawula kodwa siyalawulwa ligama into basithi alawulayo sima kwenziwe lena land affairs uveza wakhe amaphepha ngapha angqinelanayo norhulumente. Now thina njenge-members ze-CPA uzibomele into ubuyithunyiwe uyayithetha but awuzina ziphumo zibalulekileyo ebantwini abakuthumileyo. All and all Vormen kakenphinde sincedise noJeki kwinto ye-title deeds zaseDwesacwebe. Imhlaba sawunikwa ngo-2001 bazali kodwa xa ninojonga ngoku kuphele la mhlaba wawukho ngaphambili ngathi kuhle kusonikezelwe ebantwini kwavele kwadestroyeka yonke into imithi amayeza singabantu abamhlophe ndikholelwa kwizinyanya abazali mina kakhulu. Ndinamaxesha funeka ndinganxibe kwasihlanga kuyo yonke into enxitywayo ndiphile le mpilo funeka ndiyiphilile qha intsimbi ndiyayibaleka. Kodwa xa ndijonge i-constitution ngoku last month bekune-striker besikhona kwenye ye-VDs zethu amagqirha indigulise iveki yonke loo nto leyo amagqirha befoma abheke elwandle ukwenza umcimbi wophilisa umntu wakowabo khangakwazi ungena evalelwa ngumthetho wakho South Africa uthi awunalungelo ongena pha uyatrespass. So ndicela i-title deed ndike ndinyakazise yona nxa silawula la mhlaba sibe sine-title deed yethu esandleni. Enkosi.
Enkosi ke mhlanga ngaphambili aba into endifuna uqala ndiyivele kuqala uba ndive kakuhle kuthiwa umthetho okhoyo umgaqoseko uyawuvuma lo mthetho wemveli kodwa into engenzekiyo kuba ubhala lo mthetho wemveli ithethe ukuthi loo nto leyo xa umgaqoseko waseSouth Africa uvuma umthetho ngabantu aba bangawenziyo umthetho aba sepalamente. Leli phika icebo linokwenziwa xa ingabantu aba bangawenziyo umthetho. Umthetho womhlaba thina sivela umhlaba ulawulwa ngabantu zikhona inkosi kugqithwa kuzo kubana izizwe inhloko kodwa namhlanje inkosi zithatha isigqibo ngaphandle kwabantu. Nansi ingcakaphi ikhoyo okusenyanisweni kule mithetho ingafakwanga kuthi sinezinto thina phaya elwandle kwenye icala sithi kukomkhulu kuba siyalihlonipha ilwandle, nasehlathini sithi kukomkhulu kuba siyalihlonipha ihlathi. Sinamaxesha apho kufuneka sekwenza imicimbi. Omnye umcimbi ufuneka ugqitha ehlathini uziwenza, ungayanga ehlathini uyothetha nezazilwanyana awuzukwenzeka. Sinemicimbi efuneka siyogqitha elwandle, siyakholwa uba thina kukho abantu phaya elwandle esithetha nabo. Kodwa ngenxa yomthetho wethu wemveli ungafakwanga asikwazi uyenza loo nto. Enkosi.
For all the speakers, it's with regard to in Limpopo we have initiation schools, which is regulated. And
sorry, Shirami, we're not. Sorry, Shirami, just a moment. We're not over in Joburg yet. We're still in East London. I'll prompt you in a second.
Just a quick translation from East London. The first speaker was from Josiah Kwebe, and he's saying that as much as they won the case, there are still issues there are still challenges. And in fact, they would like to resolve the issue of a title deed because they feel like as the CPA, they are not in control. Land Affairs is still in control. And give an example of how they are not able to access the ocean, even though traditional healers would like to access the ocean. And the second speaker as well also mentioned the point about not having access to the ocean and the forest, which are spaces that these communities revere spiritually, and they actually need access to them spiritually. So he also pointed out that while the Constitution recognizes customary law, it seems as though it is people that are impeding the functioning of customary law. So what can be done to resolve that? Because now you have traditional leaders who are making decisions without the communities.
Thank you very much, East London. We've noted the questions. We're going to Johannesburg now. Johannesburg.
Sharon, that's my name. I'm asking this question to all the presenters. In Limpopo, we have initiation school regulation. This regulation, it's giving powers to the traditional leaders to do the initiation schools. So I find it like contravening what the practice is. Usually, if you have not gone to initiation, you can't have one. So the regulation is in such a way that traditional leaders who have never went to negotiate to initiation school because of money, they are doing it. And I've got two cases where in one instance the traditional leader had the school, only 3 children were taken there, so the community was against it, saying it's against their custom. In the other one, the chief had it without consulting with anyone. So nobody went there. So is this kind of regulation allowed in terms of how we can see recognition of customary law?
Hi, Vilmian. I think my question kind of echoes what was said in the Eastern Cape. I'm just wondering about how women have been saying customary law kind of oppresses them, and the fact that you're speaking about regulators being tone deaf and making rules and regulations for things they don't understand. I just want to know where, as a regulator or as a practitioner of the law, would you draw the line between not oppressing customary law, not disregarding it, but also not practicing like the bad parts of it, especially things like women can't do certain things, women are not allowed in certain spaces without men present, and things like that, especially around land.
Thank you very much, Johannesburg. We've noted your questions. And Durban, over to you. Durban, you seem to be very soft.
Devon team, please fix your mic. You're very soft. Devon, mic, please.
Sanibonani.
Good.
Kubhekisisa khanyeza. Sekuyisikhathi sokuthi izinto zishintshe. We cannot keep on talking one and the same thing and there is no change. So we must talk followed by the action. So Usbu Ndebele, when he took over as the Premier of KwaZulu-Natal, he said, we must do first thing first. Okay, now we have spoken large. Now we must act large. The thing we must first start by changing, because if we're talking about South Africa, you are talking about the pain in your. So now is the time to change the name of South Africa so that the name will prove us. This land called South Africa must be called Kupandlela so that we will be able to make our own customary law. My question is, how can a nation, another nation, can make laws and rules for another nation with another language, which is not understandable to the nation that is being made the laws? That's my question. That's why I come to a decision that it's about the time to abolish South Africa into Kupandlela. Our new name of this country is Kupandlela. Amanda.
Ngibingelele. Igama lami nguGumbi. Igama lika baba uGumbi. Igama lika mkhulu uGumbi. Igama lika khokho uGumbi. Umbuzo wami nginawo ukuthi uma kwaqala ukuhlukumezeka kusuka kokhokho behlukumezeka kuyo le South Africa kuze kuzofika kule generation eyimi, umbuzo uthi sophumla nini, siphumla kuphi, sibe sihlala kuphi? Ngoba lento i-generational isiyaveza nje ukuthi i-generational, noma singawacela amalunga lesiwacelayo, uma kusekhona laba abakhona lapha yana aba-against ukuphumula kwethu, sizosizwa ubani? La malungelo esithi siyawacela, yebo siyawadinga kakhulu, ayibona impela angaba isisombululo, kodwa ubani ozoba umphathi walezi ikheza la malungelo lesithi siyawacela? Kukhulunywa ngendaba yamanangzana yamatayitela. Ngiyitayitela nje ngihamba, angidinge barcode, ngiyitayitela ngihamba. Elani itayitela edingakalayo ngoba ngiyitayitela? Elani?
Thank you very much, Durban, Joburg, and East London for those questions. I've also noted some in the chat, which I hope, which we hope that the speakers. Oh, I see we have more questions in Durban. So we only have 10 minutes left, and I do want to give the panelists a chance to just quickly respond to the questions that have been there. So if you don't mind, we're going to do that first, and if there's time, we can go back to Durban. I'm going to start with Professor Nhlapo. If there are questions that you want to respond to or any comments, please go ahead. I think Professor Nhlapo may have left us. I do recall that he said that he might have to. So, Michael, I'll hand over to you as the first, for the first responses.
Sure. Thanks, Philomene. There was a question in the chat about membership and how you determine membership of a customary community. I think that is a difficult question. Ultimately, it's got to be a question that's determined by the customary law of that community itself. So, I mean, membership is likely to be hereditary, but it may also be that you could obtain membership in other ways, and there may be rules around membership. It may just be a question of, well, if you're recognized as a member by the community, then you are a member. But I think the rules might also be different from community to community. I don't think it's possible to sort of set a standard for all different communities. Then the questions from Joburg both seem to touch on an important and difficult issue, which is where customary law is potentially, well, two sides of a coin, where customary law may be in conflict with other provisions of the Constitution, whether those are gender equality provisions or any other, or where regulation is actively undermining cultural practices or customary rights. I think that was Sharami's question. So, I think that the law does have a role here. That the example you gave of the initiation schools, I think that in that instance, there would be a claim to say that these regulations limit customary practices because they, I guess, are purporting to alter customary law without going through the processes to alter or develop the customary law required by the community. And so if legislation or regulation purports to do that, to permit people to run initiation schools who wouldn't otherwise be permitted to do so under customary law, that is an amendment of the customary law. It's done in regulations that specifically deal with it, so it meets 2113 and so on. And the question would be whether that's a justifiable limitation of the right. So is there a justifiable reason for changing the customary law in that way? So I guess that would be the way of answering the question. The other part of customary laws, that there's tension between promoting customary law, but also recognizing that there may be elements of customary law that are inconsistent with other provisions of the Bill of Rights, is obviously a very difficult one. And customary law, the first thing that 2113 says is customary law is subject to the Constitution, like any other law, like any other statute or the common law. And so it doesn't have any special status when it comes to looking at rights like gender equality, like dignity, and so on. Obviously, when you're trying to test it against the Constitution in that way, you've got to really understand it properly. You've got to understand the context in which it operates. But yes, it can be. And there are cases like Bear, which are challenges to customary law provisions that are discriminate on the basis of gender. The questions that came from East London, I think, really go to one of these fundamental problems between, what we say the law should be. We sit in offices and think this is what the Constitution says, but there's a massive gap between that and what happens on the ground, whether that's the regulatory gap that Philomene and Jackie were talking about, or the gap in communities themselves, that traditional leaders are not interpreting or applying customary law in a way that the Constitution envisages or the customary law itself envisages. And the reality is that the Constitution and the law doesn't solve problems on its own. It takes people to solve problems. The law, the Constitution is just a tool. I think in this case, it can be a powerful tool to assert customary law rights, but people have to go and take that tool and use it, whether that's in debates with government or in courts or in popular meetings. But without making those promises real, it's just paper, it's just ideas.
Thanks very much, Michael. Jackie?
Thanks, Philomene. Yes, so I want to respond to two questions. So one came from the gentleman in East London, talking about the challenges that communities have in accessing the forest and the sea, and particularly for spiritual purposes. And then another question that's come from the chat, which I think touches on a similar problem that we're experiencing in the way in which customary law, and particularly living customary law, is being interpreted was a question from someone asking about African eco-philosophy and whether or not the ocean has rights as a sacred space. So I'm going to touch on the first one first, which I think, yes, what we see is that government is not really engaging with customary law as people live customary law, in that in their lives, both their practices on their land, in forests, in the sea, in order to feed themselves and their communities and to sustain themselves, as well as their spiritual practices, are often very linked. They're not in nice, neat silos, whereas we see often much more from a Western perspective and a Western worldview. Fishing rights is sort of over here, the land is over here, forestry issues are managed by the forestry department, etc. So the Western approach to law tends to compartmentalize things in a way in which we're learning that living customary law doesn't. And I think that is one of the problems, that although in particularly, for example, in Dwesa, people might now have some access to the sea, the understanding that that is for fishers and it's a sort of neatly prescribed group, but there might be Amatego who need to also access the sea for amasiko and ritual purposes, hasn't actually been fully recognized. So I think this speaks to the problem that in fact all the speakers today have spoken about, that it's about needing to understand customary law in its own setting, in its own context, and from the worldview that it comes from. And so this comes to this issue of whether or not the ocean has rights in African eco-philosophy. And to my understanding, that hasn't been expressed and articulated in the work that I've been doing on this issue yet. I mean, we see it in other countries such as New Zealand, where the rights of rivers, for example, have been recognized. I think this is something which is going to emerge, because what we are learning is that from the perspective of the customary communities with whom I've worked, for them, their relationship with nature is very different to the relationship with nature from a Western perspective. And we saw this with the Shell litigation, where customary communities were articulating this very close relationship with nature, and that the sea, the ocean, was seen as the great home. It's the home of the ancestors. And that gives it a particular status and a particular need to be protected. And although it wasn't articulated as the right of the ocean in the way in which nature rights or ocean rights have been articulated in some other jurisdictions, there's certainly an evolving understanding that the relationship with the ocean and with other natural resources is very different from an African customary perspective. And I think this speaks to the need that some of the speakers raised yesterday to really get our courts assistance in enabling this alternative worldview to be infused into understandings of our law in South Africa and how we legislate, how we view rights in the ocean in general. So this would be an opportunity for that different relationship that's coming through from customary rights to infuse our understanding of the law in relation to the ocean. Thank you.
Thanks very much, Jackie. So we must finish. In the last minute, I just wanted to say one thing on the very important question from Joburg about what you do with bad customary law. And just to say, I mean, customary law is in no way above the Constitution. So it is absolutely subject to it. I think the point that we are trying to make is that in order to bring customary law in line with the Constitution, you must first understand what that customary law is. So the Traditional Courts Bill, for example, the objective of that bill, Parliament says, is to bring it in line with the Constitution and to protect women. And the bill does the opposite. It is terrible for women because they have no idea what's happening on the ground and therefore what the impact of that bill would be. And in any event, it is so far removed that that women are not protected by law that's made in a vacuum like that. It's 4:45. I know we must go back to plenary. I apologize to the person in Durban and in Johannesburg Sien, unless you say that we are allowed to go to them before we return to plenary. I'd be very happy to do that, but you are the boss.
No indication from our other colleagues that they are done, so we can take maybe 2 questions and yeah.
Excellent. Okay, so Durban, we're coming to you, and then to Johannesburg.
Baphathi egameni lenkosi. Cha owami umbuzo nje ula mayelana nokuba kukhulunywa ngendaba yamalungelo. Ukuthi abantu besifazane bona babekwapi. Ngoba ibona abagqilazeka kakhulu kuzo zonke izinto. Uma abanalo ngishizwi, uma kuhlangenwe noma kwenziwane noma kuhlangene imhlangano noma kama meeting emphakathini emakhosini kuphi abanali izwi. Uma kuthiwa abantu umhlaba nje basikhuma ngemhlaba yamakhosi neinduna nakho konke, kodwa mawufuna ukubeka izwi nje basila emhlanganweni angithi sobuyela kubantu. Uma sifika kubantu sihlangene nabo abanumzane ema meetingini, kodwa ngeke ubakwazi ukukhipha le information lene siyithola la. Kufana nomuntu ongathi nje wena ugula ngekhanda ngoba bafuna ukuthi balulazi iqiniso lokuthi umthetho nje obushintsha ufuna la kwenzeke kanjani. Boke nibuke la ayikho induna yesifazane eyingxenye ikhona, kodwa manje enxancindezelo esicindezelwa ngayo ngoba sathwala imithwalo esingayazi ukuthi soyethulwa ngibani. Nansi enye into esiphatha kabi, noma ngabe kuthiwa ke emakhosini ethu thina yeba sinayo izinkinga ezinkulu, kodwa nje inkinga ayikhona emhlabeni, zikhona ekuboneni izinto ukuthi niyakhuluma ningabonisani. Nakho ke kunye kwesibili sengihlala phansi, izingane zethu uma kuthiwa amalungelo noma imithetho yashaywa, uhulumeni uthini ngalezi izingane zethu ayinika ukuthi ayigibele phezukwethu, ziphuza utshwala, zingamazi umama, zibhema ihunga, zibuye ekhaya izofuna ukudla ngenkani. Ngoba uyena owakhipha inamba ukuthi uma uhlukunyezwa, mina ngangayazi ingathi yahlukunyezwa, obaba bakhona bangaka nje basikhulisa babe sinikeza umthetho, hayi ukuhlukumeza ingane. Isikhathi samanje awusayithinti uhulumeni, usuthi uma uyithinta ithi iyokubopha, uma ibuya izobuyela emzini kabani, akake bheka uhulumeni uthi uthini ngalezo zinto. Umasipala akake beyingxenye yomphakathi engayithathe inqumo ngaphandle komphakathi, ngaphandle kwabantu ababheka indawo, ngaphandle kwamakhosi. Ake kuhlangane uma kwenziwa imithetho eqinisile nohulumeni mayizoshaya umthetho, akake buye kubantu, abuye kumakomiti akhethwa umphakathi azohlala nawo ukuthi nakhe sicabanga ukukwenza yonke into ibisikhathi yenzakayo. Ngoba endaweni uma ubeka umuntu, inkosi ayimbeki umuntu, induna ayimbeki umuntu, umuntu uvunywa ngumphakathi. Ngiyabonga.
Greetings. This is Gongqose. My question is about customary law. What does this law say about women and the role of women in the community? Because we see that women are not allowed to speak in public meetings, and even in meetings in traditional courts and traditional councils, there is no female induna. Government is passing laws that restrain parents from disciplining their children, but is not passing laws that protect women. Thank you.
Thank you very much, Durban. Joburg?
How people can assert customary law. We have a serious problem where, especially traditional healers, right, who get their amayes on the side of the road, anywhere where such medication can be found. And you see the police picking him up. Now, they will say there's a sign 30 kilometers away. Now, can you just find out exactly what is the coverage of a road sign indicating that nobody should be in that area? At the same time, we're saying, what sanction would such an alleged transgressor be suffering? Thanks.
Hello, good afternoon. My name is Solomon Mabuza from Komazi local municipality in Mpumalanga. I do have a problem with a COCTA in our government, because government promised the people that our government should have 3 spheres, which is a national, provincial, and local. But now we have a COCTA, which is the interference of traditional leader to the local municipalities. Now we are facing a very big problem of slow service delivery from the local municipality because of the interference of traditional leaders with the COCTA in local municipality. We are facing a very big problem of selling our land by the traditional leaders. And the allocation of land and planning with land is a responsibility of the local municipality under SPLUMA or spatial planning and land use management. But now, traditional leaders, they do as they want. So we really confuse who is monitoring traditional leaders and the local municipality. Government must do away a traditional leader in the local municipalities, because there is a stumbling block now. There is no service delivery. Our land is selling even to the foreigners, and no one is is monitoring the traditional leaders as they are doing now. I thank you.
Thank you very much. I think those are our questions. Michael has asked that we go first this time, then I'll hand over to him. And I'm sure we have very little time left. But I want to address the very important question from Durban about the lady saying, what does customary law say about women? Because in her experience, it is incredibly discriminatory against women and excludes women, etc. So the first thing to say is that there's not one customary law in South Africa, so communities all have their different customary laws. And we are aware that in many communities, such as I think the one that the lady comes from, that certainly the way customary law is being applied is incredibly discriminatory and exclusionary of women. And so the job of so this session is about how does Parliament write laws about customary law? So the job of the state is to write legislation that abolishes the bad practices in customary law. So it's the job of the legislature to write laws that would protect women effectively. And as the lady says, they have failed miserably in doing so. And we are trying to understand. I think we all accept it's not an easy thing to do necessarily, but we are trying to understand how to do that best and most effectively. And that has just not happened at all yet. I'm only going to say that, Michael. Is there any...
Just on the issue of traditional leaders participating in municipalities, I mean, it's provided for in the legislation that traditional leaders are meant to be present. They don't vote in municipalities, and obviously the intention is that it's meant to be enabling, so that the municipal council is aware of concerns of traditional leaders. Traditional leaders are aware of what the municipality is doing, so you can have that interface and communication, and that's what it's meant to do. But obviously, if it's not doing that, then there's a problem with either the traditional leaders or the representatives on the council. I'm not sure that doing away with it is necessarily the the correct solution. It might be just to abolish the idea that traditional leaders have a observing seat on the municipalities, but I'm not sure that would resolve the problem if it's really a political problem of connections between politicians and traditional leaders. That's just a formality. It's about getting the right traditional leaders and the right politicians.
Okay, thank you very much. I see they're about to close this room, so we absolutely have to close now. Thank you very much. I mean, there's so much more in the chat that we would have wanted to respond to, but I think a lot of that is being picked up in many of the other panels. So thank you very much. We return to the plenary now just for our closing for the day.